it was really important for me to put something together for single parents, because I'm a single parent. I have two kids, and I know I've always worried that if something happens to me, what will happen to my kids? So they go with my mom. They don't have a dad. I feel like I would want another parent to take over that primary caregiving role. So when you don't have that kind of comfort or that hole in the bag where, okay, well, they just go to their dad, you have a kind of special set of concerns, and you need to do some increased level of planning to make sure indeed what you want is what happens when it comes to your kids. So again, my name is Eleanor Curry. I am the managing partner for the Curry Law Firm, and I've been an attorney for about 10 years now, but I can tell you that being an attorney can be kind of anticlimactic in the sense that there's a lot of disappointment. There's a big jump from what we do as attorneys to how clients experience us and what they expect from attorneys. And it's been my goal to kind of bridge that gap, because I don't like people feeling afraid to ask attorneys questions, or thinking everything is going to be nickel and dimed, and thinking that they can replace an attorney's advice with just what they find on a Google search. So I really do try to make sure in my practice that we're giving out information, which is what the point of this webinar is, but also targeting it to the clientele that I have, which tends to look and think and come from the same communities I come from. So I like to make sure that my firm addresses kind of the uniqueness of that experience, and gives people information and empowers them to do something with that information that behooves not just them, but their legacy, their community, their kids. And that's what motivates me and really inspires me as an attorney. So that's what I am, and that is my why. I'm a single parent, and when I did my own estate plan years ago, they were the top. At the time, I just had one daughter, but she was at the top of my list of concerns. How do I make sure she's provided for? How do I make sure that if someone is left to care for her, they really can care for her, right? That they have the financial support that they need, that I've given them the guidance so that they're going to do things in line with how I would view it is important to raise my child or my children. So that's a hard question to ask yourself, and an even more challenging question to put a plan in place to make sure that you are honoring your own wishes, or you're making sure that it can be a reality. It's not just like a hope and dream. Now, lots of people say, well, I'm just going to bet that nothing ever happens to me. I'm going to bet that everything will be okay, or that my family will rally, or that my mom will still be around. And although these are hopeful aspirations, the reality of being a single parent is we know far too well what the reality is, that we may have high hopes for people, expectations that they will go above and beyond, expectations that they'll be there to support us, and the reality may be a little more disappointing. So we have to plan for our kids' best interests, and that often means putting together contingency plans, putting together some what ifs, and making sure that whatever plan we put, there's somebody in place and empowered to put that plan into action. So what is estate planning? Essentially, in its most basic form, it's documents that you put together in case of your death or incapacity. So, and commonly when we think about estate planning, you put together your will, which is what happens to you if you die. You put together your trust, which may be what happens to you in life. It will also cover incapacity, and think about a plan outside of just a designation at death. And then a healthcare directive. As a single parent, this is one of the most important things you could put together. Who would be making decisions for you if you are unavailable to make decisions for yourself? Oftentimes, without question, if you don't put a plan in place, the statutory regulations will put that plan in place for you. So it will go to your next of kin. If your parent is alive and has the capacity to make decisions, if your parent is not alive and your children are not above the age of 18, it will go to, the people outside of that. So if your parents are unavailable, you don't have kids that are old enough, it will go to your brothers and sisters. In my case, I don't have brothers and sisters, but you may have brothers and sisters who may be the very last person on your list to make these decisions for you. So the healthcare directive provides medical professionals with ability to talk to the person you would want to make the decision, as opposed to the person that the court would say is appropriate decision maker for you. Same with the power of attorney. If anything happens to you, somebody still needs to, if you have kids, they still need to pay your bills. They still need to make sure your kids can go to school. They need to make sure your house doesn't go into foreclosure. And that power of attorney document allows someone to have the financial responsibility to go to the bank and make withdrawals for you, or pay your bills, or speak to your creditors on your behalf to let them know that there will be an interruption, or there'll be a delay in payment. So all of these, especially for single people, are very important. Even if you don't have a will, even if you don't have a trust, putting together a healthcare directive and a power of attorney can really empower whomever you want to step into a running position when it comes to your care for yourself personally, or for the care of your children. It gives them an upper hand and a running start to get things done. So we talked about the basic plan, which is estate planning. But what I also like to encourage people to think about is ways that those collection of documents can be moved to what I like to call a life and legacy plan. So it's a plan for incapacity and death. And yes, it comes with some of the documents that I mentioned in the last slide. But what you really want when it comes to this type of planning is clarity on the legal ramifications and the financial ramifications on if something happens to you. So lots of people say, well, why do I need to do an estate plan? Because I don't really have much, and whatever I have goes to my kids. But when you think about legacy planning, you're thinking, if my son's 8, he needs another 10 years of care as a minor, and maybe 4 years of college, and where I still want someone caring for him. I want him to have some financial support. How can I make that happen? So if something happens to me tomorrow, have I considered what he would need for the next 10 to 12 to 14 years? And have I put a plan into place that would make whatever my care concerns are for him possible? So that may mean I'm getting a life insurance policy so I can make sure that he can, even if I don't have the funds in life, that he can be cared for in death. Am I making it so that he could sell my house, or whomever I would want to care for him can live in my house, so he always has a place to stay and a place that he feels like he can call home? Have I thought about dividing, or if I'm leaving money to someone, have I made sure that that person is financially capable? Lots of times it's very easy to get a term life insurance policy. It may give you $1 million to care for your beneficiaries. Are you putting someone in place who's ever put their hands on $1 million? If you haven't, there's a very good chance that they aren't going to be the best financial manager, not because they don't want to, not because they're just diligent, they don't want to help you, but because they really don't have the skills and understanding to do a good job. So when you think about what you want, and then you think about how you can put it in place, that's where planning begins. So I would say a will is like a disaster plan, right? If something happens to me, divide things these ways. But a legacy plan is, if something happens to me, I've put things in place to put my actions in motion, my wishes in motion. So I've provided a life insurance policy for the guardian. I've, provided instructions on how I want my kids schooled, or if I want them to have some access to funds for certain earmarked things. I want to make sure my daughter has a beautiful prom, right? That's something that you can decide and put a plan in place, no matter if you're here to provide for yourself, or if you're asking someone else to carry out your wishes. So it really just asks you to put the energy that we already put into our kids' life as parents into how you want them to be cared for if something happens to you. So this is a place where you're going to enroll the help of a trusted advisor. That certainly should be, one of those advisors should be your accountant. Hopefully that's an attorney as well. And then you're thinking about whatever I want in place, how do I make sure I have the documentation and the proper understanding so that that plan actually happens if something happens to me. So I just thought I would give you just a quick peek into what the differences are between having a will and having a trust. And because those are the two basic vehicles that we use for planning on for death or incapacity. So, one of the most important differences is that in the case of incapacity, a will is not triggered. It only is triggered if someone dies. So, if you die, someone takes your original will to the court to have it probated. If you are just, in a vegetative state or in a car accident or you go missing, it's not triggered. It won't help you at all. So a lot of times people put a lot of confidence in a will, but you may not have a situation, or a worst case scenario for you may not be that you turn up dead. It may be that, there's an earthquake when you're visiting Bali and you're unavailable. How can people provide for your kids if something happens like that? And so a living trust allows you to put some plans in place for incapacity, for unavailability, that a will won't allow you to do. Another thing is that both wills and trust allow you to distribute assets at your death. And that means you're going to pick people, your kids, or whomever you designate as beneficiaries. But a will is going to distribute everything, and then they're going to close probate and it'll be done. But a trust will allow you to have what I call like a long reach. So as a parent, I want to make sure my kid is provided for, not just for the year after I'm deceased, but for a long time after that. And so a trust allows you to put a plan into place that's not just about a distribution, meaning you get this, or if your kid's a minor, whoever is their guardian gets this money, and do your best to take care of my kid. You can put some plans in place that really talk about what you will want to happen, how they should be schooled, if you have a house that you want them to continue to live in the house. All of those things can be put as instructions in a trust. The assets in a will are going to be probate assets. The things are going to do in an inventory, and the things that are in a trust are going to be assets transferred to a trust in your lifetime. Or if you have a pour-over will, which is a will that just kind of says everything that I didn't put in a trust in my life will now go to the trust. Again, the effective date for a will is at death, and a trust becomes a living, breathing thing at the time you fund it. So if you take if you have a trust, you take $10, you open a bank account, you now have an active trust. A will is probated in court, so it is a public record. A trust is not, because it's private. However, the designation. Let's say you don't want your sister to care for your son or daughter, right? You can put that in a trust, and it doesn't have to be public information. It doesn't have to be a debatable piece of information, and it's not something that people can contest. And most importantly, if something does happen to you that includes your death, you will avoid probate with a trust, and you won't with a will. So I think at this point, you got enough of the basics, and some of them you may have already known and considered. You really have to think about what you are doing it for, because if not, the questions and the thought around, okay, I'm going to die, who's going to care for my kids, those questions can be overwhelming. They can be unpleasant, and it can be easy just to brush it off into, I don't want to think about it, I don't want to worry about it. And then at this point, I know I'm 42. I've had people in my life who are my age die of cancer, die of car accidents, die for all sorts of reasons. And so the concern is always like, wow, I hope they had a plan in place to care for their kids. And it, as much as that sadness, is triggering, you really have to follow through and think about your kids and how you want to honor them and still be the best parent you could be, even if you're not physically here to do it for them. So use that, whatever your motivation is, whatever your who you do it for answer is, as a motivation to put a plan in place and make sure it's the best plan that you can do for your family. But the truth is, you do it for yourself too, right? You want to continue to be the parent you know yourself to be. You want to continue to feel confident that you're a good provider and caregiver for your children. And so I like this quote. It says, self-compassion is simply giving the same kindness to ourselves that we would give to others. And we're in a weird place in our lives where often or at least in the foreseeable future, you may have to be the caregiver for your own children, but also for your parents, right? And so the age where we could just rely on going and, the grannies pick up the kids and things like that, we may not have that same ability to rely on our parents to care for our children. In fact, they may need care from us, and we have to plan for that as well. So, I mentioned probate. It only is triggered at death. You get that public record, you go to court and file open a probate matter for your will. The court will review things. You'll gather assets. You do an inventory. Most likely, you'll liquidate things unless you left some other provisions in your will. And then maybe a year later, and $5,000 to $7,000 later, people will start receiving the distributions. As a parent, that's almost impossible because, I would say I have friends I love, friends I trust, but do I believe that any of my friends can just take on my son, care for him financially, care for him emotionally in, the event something happens to me? No, they would need assistance. And it's my job as a parent to make sure I've put a plan in place so that they can get the assistance from me. But if all of my assets, all of my money, all of my funds are in probate for a year, how am I doing that? And that's an important question. It's one you have to have an answer to because, often we don't even have the discussion with people who will be left in charge on what their role would be and how we could help them. So somebody may be surprised, okay, well, now I'm somebody's guardian. How do I do it? Where do I live? What is their school? And what is your intention? Because if you trust someone enough to raise your kids, chances are you could trust them enough that they will want to do what you will want them to do. But you can't assume that they know. So I don't care if your plan that you put in place is just a note of things that are important to you that you will want someone to take away from when it came to raising your kids. And that may be a reminder to you on how to be the best parent you can be and put things into place in your own life that are important to you when it comes to rearing your kids. So it may be something formal. It may be a power of attorney and a medical directives. You may get a will, you may get a trust. But if you don't do anything else, leave some notes to someone. Make that note to your kid and to someone you want to care for your kid in case something happens, so they at least are empowered to know that they're doing the things that you would want them to do. So let's talk about some unique issues for single parents. If something happened to you, first and foremost, like right now, I had to leave right before the webinar to go pick up my son. If I never picked him up and school called and they said, we can't reach Eleanor Curry, who is the next person available to pick up your son? Who would it be? And have you really empowered them to do more than just a school pickup, right? Are they able to, are they authorized to do things on your behalf? Because something happens to you, that might just be a car accident. You're on the way to pick them up, you're in a car accident, and you're fine or you're alive, but there are no instructions on who even has authority to pick your kids up if you're not there, or they're with a babysitter, a 14-year-old, 15-year-old, 16-year-old babysitter. What do they know how to do? And who can they call? So I mentioned in the call, in the recording I had the other day, you can do something as simple as put a note together on who has immediate permission from you to pick up your kids. And what this does, and this is just a little card. I normally laminate them, but it's just a little emergency identification card that you could put together that says, here are the people authorized to act if I'm unavailable. And especially if it's a question where social services are called because no one else shows up, you want some plan in place and some authority granted that tells them who you will want in your absence. And so I encourage people to think about it first. Who would be available to do something quickly? That may be a neighbor. That may be someone who lives close. And then you may think about people who do things more on a long-term basis. So that may be your mom, if she lives close, or a sibling, or even a good friend. But that friend may not be as instantly available as your first responder. So make a list of your first responders. Make a list of people who are more in line of guardianship. And sometimes these lists are the same. And sometimes you're in a city all by yourself and these lists are not the same. So who you will want to care for your kid if you are unavailable for 3 days may not be who you want to care for your kid for another 10 years. and just understand the difference. And those lists do not have to be the same. Oftentimes we get stuck in guilt. Oh, I don't want to tell my sister I don't want her to raise my kid. I don't want my mom, she would be offended, her feelings would be hurt. Okay, what's more important? Someone's feelings being hurt? Are you doing the best to provide for your kids? And so sometimes people's feelings are going to be hurt, and that's unfortunate. And sometimes having, honest conversations with them lessens some of that concern. But at the end of the day, you have to do what you think is best for your kids, because there's no one else who can do it the same way you would and who would do it better than you would. So feel empowered as a single parent in that space that, we are real advocates for our kids. We take on the weight of the world to protect them and to provide for them. And you can continue that through the question of death and the question of incapacity. When it comes to financial security, I always tell people, do not choose someone to be a guardian for your kids solely off of financial responsibility or their financial situation. That may mean, the richest person but they may be the worst parental figure that as well, right? They do not have to be the same people. You can completely choose a different guardian than the person you assign as the financial responsible party. So you could have someone who manages your trust or gets the distribution of your will, and then they're going to set a plan in place or follow your plan on how you want funds distributed for your kids. So when it comes to that planning, this is where life insurance can be very important, because if you say, right now I don't got it, I'm worried about how I'm going to take care of this kid in 2 weeks, much less thinking about, them in 10 years. Think about a life insurance policy that helps empower you and enable you to put that plan in place and make it something that can become a reality. So use insurance for things you don't have. If you say, my kids are young and I don't got it for the next 20 years, anything, all my assets, if you boil it all down, I couldn't cover them for 20 years, then think about other ways that you can cover that financial responsibility. And that gives you the freedom to choose who you think will be the best caregiver for your kids without having to think about, could they be the best provider for your kids? Use a vehicle, if you don't have the assets, to become the provider or to remain the provider, and then just choose the person you think would be the best parent, the person who would be most like you perhaps, or the person who would honor your wishes and raise your kids the way you would want to. I have a client who said, look, the family I love and would choose as a guardian, they have a weird thought around same-sex marriage and homosexuality. I want my kid to be whoever they are, and I don't want them to feel embarrassed or stifled in a place where that type of whoever they are would be frowned upon, right? And so you have the power to make these decisions. Don't feel like you just have to pick the safe choice, pick your mom. Think about what's important to you, who you can trust in that way, and find ways to empower them. Because ultimately the goal is a long and best interest of your children or your child. We talked a little bit about trust, and while trust is an option, I'm not here to say it's the only or best option. Trust can be challenging to put together. That can be expensive. So you can tier your plan to whatever level or interest you have. They may start with some documents on what to do in case of my incapacity. That may be a power of attorney and a medical directive and a HIPAA release. And then you move up as you grow in assets, as you grow in options, then you just keep adding to the plan. But where I would say the plan starts is writing down your intention, putting together some basic docs, and then moving based on your circumstances to either a will where it's going to be distributions at death, or a trust that will talk about, distributions that go beyond just a designation of a beneficiary and them getting a check from you, right? You can put different plans into place in a trust. But even that's not enough if you don't follow up, if you don't let that plan evolve with how you are. So, when I put my first will in place, I started with a will. And when I put my will in place, my daughter was maybe 8 years old. Well, now she's 21 and I have an 8-year-old son. The plan is completely different because she doesn't need the same level of care. The guardians that I put in place for her when she was a young child are not the guardians I will put in place for my son, who has, a different father, who has different concerns, a boy versus a girl, the different level of energy, they are not the same. And if I just put a plan in place and put it on the shelf and forget about it, I've done myself and my kids a disservice, because I have to think about them. I have to put their interests first, and I have to make a plan that encompasses what I would want for them, considering who they are and where I am, right? And so the best plan I could put together for somebody today, if something happens in 10 years, it's probably a garbage plan, right? Things have changed, people have changed, your situation has changed, and you have to remember to whatever you put in place, bring it with you. Don't, it's not an elf on the shelf. It's meant to be a reflection of who you are at different stages in your life. So make sure you're updating that plan, you're revisiting it. Maybe when you put a plan together first, your mom was 60. In 10 years, your mom's 80. Maybe she's not the best guardian for your kids, right? Or maybe you have a different set of friends, and maybe your relationships with those you entrusted a decade ago have changed. So make sure that that's a document that moves and ebbs and flows with you as you evolve in life. So most lawyers, and even how I practiced previously and do yourself plans, they tend to fail in a couple of different areas. And some, I can't say, for instance, I can't say for certain all lawyers don't do it right. But I will say what's important what are important questions that you should ask. One, who will know what to do, right? If you have something great set up, but no one knows where to find your docs, if you have a will, no one knows where your will is, it's not a great idea. If nobody knows what accounts you have and has authority to actually get funds out, it's the plan has a hole in it, right? And you want to ask yourself, okay, I have this plan in place, but who knows what it is? Who knows what it is and how to find it? If you have kids, again, that kids protection plan, you want to make sure that you've asked yourself, if my kids get picked up by social services or the police, who do I given authority for them to let be responsible for my kids until they figure out a permanent situation if it's necessary. Um, will your family and friends know what assets you have and how to find them? If you don't claim assets, let's say they have a bank account, and you don't tell them the bank account name and number, the bank account doesn't go running around searching for you to give you back your money, right? They may they may have an account, charge account fees for 10 years before they turn that account over to unclaimed property. Your family doesn't know, it doesn't benefit your kids. And then in that sense, it hasn't done what you intended it to do, and it may never reach your kids if it goes to unclaimed property and they don't know about it. Are you leaving your loved ones with a competent plan and some guidance from you on how to execute that plan? And if you're leaving them with nothing, have you given them instructions, even with that, what you may consider nothing? Because chances most of us have some sort of level of assets, and maybe a car. And you may say, I have a note or bill on everything. Some of that can be worked out. Some of those can be transferred. Sometimes people can assume debt. But if they don't know, then the path to get them there will be pretty challenging and almost impossible. So I wanted to stop there because I said more than a mouthful and I tend to talk pretty quickly, but I wanted to make sure I left time for questions to see if you guys had any questions. If you had some things that were personal to you or some concerns that are, your concerns, I'm happy to address them now if you have them. And those concerns may be how to put a plan together with a co-parent that you may not always be on the same page with. I think everybody's mic can be turned on. Let me make sure. Okay, so if you have questions, you can just unmute yourself and ask them. If not, what are some ways? So if you are a single parent and you have either an ex or a active co-parent, how do you navigate your will or your trust and your interest with your kids, right? So I would say that can be a difficult situation. First things first, you have to be willing to have that conversation. It's not a fun conversation, not an easy conversation. And that conversation may indeed say, while you may get custody of the kids or I'm going to hold you responsible to care for the kids, I'm not empowering you. I'm not leaving you $1 million. I'm not leaving you my house. I've put a plan in place so that they can access the funds as I've designated or as they need it, but you aren't the person responsible for those distributions. I've put someone else in place. She knows the plan that I have. I want the kids to go to this school, or I want the kids to live in my house if they want to. And so sometimes that conversation is just really directing them. Here's my plan, but you aren't the the financially responsible person. And I think it's common in relationships that one person is really good and really savvy at finances, and one person may not be. And so you may have a legitimate concern that leaving finances intended for your kids to a co-parent ends up with your kids not getting what you intended them to have, and a co-parent, buying a Lexus or buying a new house, and living on the high horse with a new spouse, right? So I would say have a conversation, but don't be afraid to segregate those interests so that financial goes here or guardianship goes here. And even if you want them to be a part of someone's life, if they're not the kind of parent who can handle full-time parenting, you need to be prepared and at least think about what those alternatives can be. Can they live with my sister and still go to you on the weekends? If they don't live in a vicinity or the same area that you live in, what will be the plan? Do I intend for them to move? Have I put finances in place for them to stay in place? Those are all questions that you have to ask yourself, but have the conversations not just with your co-parent if you have one, but also with guardians that you would have in place, or people you would have on the financial responsibility side. So you can either ask a question if you have one, and you can turn your mic on and ask a question, or you can use the chat box. If you don't want to turn your mic on, you can always chat away at the bottom, and I'll make sure to highlight your question and answer it on here. All right, so let's talk about some common myths that people have when it comes to why they need an estate plan or why they don't need an estate plan, right? First things first, people always say you don't need a plan. If you only need a plan if you have money, right? And so wrong, right? Being a parent required $0. It was free 99, right? It can just be a long night of fun. Now you're a parent, right? And so planning for your kids is not just, I'll have all this money and my kids are going to go live the high life because I'm rich. It may be just a plan in place, an expression of your interest. And I talked about that earlier. So if you want some input, if something happens to you on how your kids are raised, that's for you to put into place. It's up to you to put some notation down of what your interests are, because as best people can know you and you think that they know you will, they may just misunderstand your perspective on parenthood or your perspective on schooling or your perspective. I had a client, he's high up in a bank, but he said, I'm not leaving my kids money to go to college. The money I have for them, I want them to be able to start a business or buy a house or do something that's an asset that they can remember me by, but this money's not for college, right? And so you can put a plan in place no matter if you have lots of things that you want to provide them, or if you want to provide them just some legacy and some intention and some lesson from your life. So put a plan into place, and then you can begin to start thinking about how to work that plan. If you have a spouse or ex-spouse or co-parent, well, they'll just be in charge anyway, so why do I need to put a plan together? That may or may not be true. Don't assume that is true. Put a plan together, and if you have some concerns on who they would be if something happened to you, especially put a plan in place, right? And a plan where people can understand your plans, and you're not just throwing your kids in a fire that you wouldn't want them to go through if you were living. And then the last but not least, I don't have money to pay an attorney. I will make sure to send out to everybody a link to the Kids Protection Plan program. It allows you to put some basic guardianship plans into place. But you can start anywhere. So it doesn't have to be some $3,000, $4,000, $5,000 plan. Start anywhere, put together the docs that are accessible to you, and just make sure that your kids' interests come first and foremost, even to the thought of, hey, I don't have money to afford a plan, or I'm worried that what I could put in place would be insufficient. Okay, well, that wraps things up if you guys don't have questions, because lots of time I leave a space for questions. I did want to make sure that I mentioned that I'm happy to meet with you one on one if you have some more specific questions and you want to figure out, hey, can I do it myself? Do I need the assistance of an attorney? What level of planning do I need for this my situation? There's no plan for everyone. There's no universal plan that works for everyone. So this is a plan customized to you and to your situation, what you want for your kids and what you want for yourself. So you can try to figure that out yourself, or you can, put together some time. I'm happy to talk to you about it. And that gets to our last slide. When it comes to talking to me about it, we're happy to assist people, and that may just be an inquiry session where you're getting more information, but we do offer that initial planning, that initial consultation, as well as $250 off any estate planning package to those who come to the seminar. So that will be emailed to you and honored at the law firm for your availability. So next steps, if you are moving forward, you want to make sure to complete an inventory to kind of give us an idea for our discussion if you want to take advantage of that. But if nothing else, start writing down what your plan would be and then empowering yourself to put that plan together. Thank you so much for attending this webinar, and we look forward to hearing from you and feeling comforted that you've put a plan in place that's great for your interest. Thanks.